All right, so yeah, like this. So it was really nice the way we started this then. And I will be moderating this session, and I'd like to speaking about our open society, speaking about the role of autonomy of the prosecutorial service. So should I just give it the microphone? And
thank you very much, Taylor. I'm already 3 moments in the workshop right after lunch, and so I hope that speaking of prosecutors will contribute to keeping awake. So I discussed with Carolina of what could make sense for such a short presentation, and we agreed that I would somehow go back to the basic of what it means. What it means, this concept of independence of prosecutors, and quickly go through the different components. So apologize for those of you, and perhaps all of you who are really familiar with this topic, because I did not really go in depth of this different components, but of course we'll have the opportunity of the discussion during the discussion. And I will also try to highlight here and there where our organization found the opportunities to litigate or to contribute to litigation around prosecutorial independence. So, but I wanted to first come back to the basic question whether it is relevant to speak about the independence of prosecutors, because when speaking with people and colleagues across the globe, sometimes there is some confusion, and some people saying that no, prosecutors are not independent, which are not meant to be independent. And I personally and many, I think there is a common understanding, agreement across the globe and within international bodies that yes, prosecutors need to be independent. And one sort of the confusion, I think, is the fact that prosecution services have structure and that may be very different from one country to another, depending on the culture, etc., etc. But yet, despite these differences that we have to acknowledge and take into account when implementing the independence of the prosecution services, they are important common features and value, starting with the fact that prosecutors should act, in a fair way, with transparency and in the interest of justice, and these common features and value are somehow more important than their differences when it comes to the very notion of prosecutorial independence. And of course, we all know here around the table that prosecutors, if not making the final decisions, they have an important role and covers, starting from the fact that they can decide or not to prosecute or not. They can indict people. They can also request, for example, for delivery of arrest warrants. And it has been made very clear from by many regional and international bodies that one of the key aspects is for prosecution offices is that they need to be free from any undue interference, and the most obvious one is, of course, interference from other powers and the executive power. And I very much like this quote of the Venice Commission, dated of 2010, saying that political interference in constitution is probably at all at society itself. So it has been an ongoing challenge. And just to say that a couple of other elements is that the two main risks of prosecution services under undue influence, of course, the risk of prosecution, and someone this morning said that some people in the country, I think it was in Hungary, have not been prosecuted for years, despite wrongdoing, and the risk is also over prosecution of opponents, protesters, etc., etc. And so the UNODC stated already in 2014 that the independence of prosecution services is a fundamental component of the administration of justice, and the Consultative Council of European Prosecutors stated that any influence that affects the independence of prosecutors is likely to affect the entire trial. So after this really basic introduction, I would like you to walk through the different norms and something important that happened lately last year is that we really started moving in the field of prosecutorial independence from only soft law at international and regional level, from only soft law rules to binding rules, at least at the level of ECHR and at the level of the inter-European system of human rights, at least for some specific questions. So here I put in the presentation so that you have it available some of the main sources, and you can go through. I won't quote all of them, but from the UN, from the Council of Europe, from the inter-American system, and from the African system. So you have it's not comprehensive, but you have the main soft rules that speak about the independence of prosecution services. So if you can go back to slides before. Yeah, so as I said, in 2020, we started having some binding rules from European Court of Human Rights and from the Inter-American Court of Human Rights. For the very first time, judicial courts stated that prosecutors are to be independent as a key component of the judicial system, judicial independence, and the rule of law. And so the first decision, certainly very well known for many of us, was the decision of the European Court of Human Rights in the case of Mrs. Kovesi against Romania, a decision of the 5th of May 2020. So Mrs. Kovesi was the anti-corruption chief prosecutor in Romania and was dismissed by the President, my recollection is correct, as the request of the Ministry of Justice against the opinion of the High Judicial Council. And so he filed a complaint with the court on the basis of Article 6 and Article 10, freedom of expression as well. And the court has interesting quotes in this judgment about chilling effects of this kind of dismissal towards the judiciary, but in the decision, the court made it clear for the first time that the principle of independence of prosecutors is a key element for the maintenance of the judicial independence. And a few months later, the Inter-American Court of Human Rights issued two decisions making similar decision, making similar ruling. Here, OSGI acted as a co-counsel, and it was kind of opportunistic intervention from our part because we really wanted to make sure that the Inter-American Court was aware of the very last judgment of the European Court. It was very interesting because the expert brought by the Colombian government state brought very wrong and wrongful elements about standard from the Council of Europe. And next slide. So in this decision, Martinez against Colombia, so it was about a provisional, it was not about the chief prosecutors, that was the difference with the Kovesi case, but still, Mrs. Martinez was a provisional judge delegated as prosecutor, and she was investigating corruption-related cases, and was ordered by her superior to terminate the case. And she, I will get this long story short, she refused to take the go. no, there are still active investigations that are needed. And so she was eventually she was then dismissed, and she went to the commission and then to the court. And the court stated that the principle regarding the need to secure independence of judges apply also to prosecutors. And the court also gave somehow guidance about the need to protect the prosecutors, their independence through appointment processes, vulnerability, and the protection against external pressure. So these are, the binding rules I'm aware of regarding procedural independence. So securing the principle and also giving some indication on dismissal process of chief prosecutors and prosecutors. Now, in this third part, I would like to quickly go through the different components of procedural independence, because there is no one single way to secure procedural independence, like in judicial independence. You need different elements, different standards that here needs to be developed. At three levels: institutional, organizational, and individual. I will come back to them. So how this will be framed and applied in practice may vary from one country to another, depending on the legal and political culture, but yet their principles are critical for the independence of prosecution services. So I will go now through these three levels, not going in depth in the different subcomponents. I will focus on one or two. So first, of course, when speaking of independence of prosecution services, there is a need to secure independence vis-à-vis the other powers or institutions. And to secure this institutional independence, different requirements are needed. One being, processes for appointment and dismissal of heads of prosecution services. In the case of Kovesi, the court made it clear that even if she was chief prosecutor, there was no possibility for executive power just to remove her, to dismiss her as a chief prosecutor. And the fact that she remained a prosecutor was not sufficient. So the court acknowledged that a dismissal of the chief prosecutor can only be made through the intervention of an authority independent of the executive and the legislature, and the court also stated this for appointment processes. And I know that there are debates, we discussed with Radoslav in the morning whether chief prosecutors should be secured against dismissal, but I think that the ECHR needs clear indications. Another aspect of institutional independence, and there things may be very differently from the judiciary. It is about instruction from the executive to prosecute or not to prosecute, and also the question of with freedom of decision to withdraw or uphold prosecution. So when it comes to organizational independence, so it's about the relations between the heads of institutions and the members of the prosecution service. Various elements in that regard, of course, how do you just distribute cases among the members of the prosecution service, and also whether a senior prosecutor or the head of the prosecution office can interfere in individual decisions, and upon which conditions. So, for example, the Venice Commission has developed some standards in that regard. That I think should probably be strengthened and reinforced. Also taking into account, and it's very important to take into account what is the culture of prosecution services, which is a very radical organization. Yes. And then the last level is the individual independence, so the status of the prosecutors. So one element is the security of tenure of prosecutors. And so the decision of the Inter-American Court of Human Rights states clearly that irremovability contributes to the independence of the prosecutors, and that there is a need for a legally established code of procedure complying with requirements of objectivity and impartiality. I think we can say that, for example, at the level of the Council of Europe, there is, I think, an agreement to say that they should be a life appointment for prosecutors, which was not the case in the Inter-American system. And of course, the independence will be secured through proper disciplinary proceedings, conflicts of interest, and also functional immunity. We spoke about the immunity this morning about judges. There is also a need to secure functional immunity for prosecutors. So that was very fast, speaking about the different components of prosecution, the independence of prosecution services. And my last word will be about accountability of prosecution services, because I don't think one can speak of independence of prosecutors without speaking about their accountability. Because what we observe in a number of jurisdictions is that prosecution services become completely independent from any other court and not accountable. And so, if they don't prosecute, people that should be prosecuted, there is no way to hold them accountable. So, I think that it's really important to have this both elements in mind. And there are interesting lessons from regional bodies, such as, for example, the UN Special Rapporteur on the independence of judges and lawyers. That made it clear that there is a need for transparency and effective mechanism of oversight of prosecution services. And in a joint statement of the consultative Consultative Council of European Judges and Consultative Council of European Prosecutors, they also say that prosecution services that is not accountable, that are not accountable, can endanger, and it's a very strong language, endanger judicial independence and prosecution credibility and human rights. I couldn't even more. And then just a few thoughts on what it means, the accountability. There are at least two levels. It's the accountability of the institution itself and accountability for individual decision. So accountability of the institution is of course critical and requires different various elements. So for example, does the prosecution service adopt prosecution policies, for example, to making priorities on the case to prosecute, especially in the systems governed by the opportunity principle? And are these prosecution policies published and available? Are there annual reports published by the prosecution office? And another critical element is all about data. The number of cases that entered the service, the number of cases that were closed, the number of cases that were prosecuted, that were dismissed by type of crime. That these are all very, very important elements. And then last but not least, it's the accountability for individual decisions. So if the prosecutor decides to prosecute someone, the court decision will be a way to hold the prosecutor accountable for its decision. But what if in the cases where the prosecutor decides not to prosecute? And here again, I found this quote of the Venice Commission very, very appealing, saying that the biggest problem of accountability, or better said, lack of accountability, arises when prosecutors decide not to prosecute, and then there are no remedies to force, to force a review of such a decision. And just for, there is a case pending before the European Court of Human Rights against France, Bitburg against France, that touches upon this question of accountability. It's in a specific context. It's a context of extraterritorial jurisdiction of France, but still raises this question of the absence of remedies available for victims. The only remedy that is available in this kind of cases in France is an appeal to the prosecutor general. We need to say that it's very, very ineffective. And so we submitted an OHI and a TPI to draw the court attention to the need to strengthen the accountability tool. And one of the tools we rely on is the EU directive on victim rights that I think really can offer really interesting elements. Article 11 is about the possibility that victims must have to ask for a review of the decision of the prosecutor not to prosecute. Yet the directive itself is not very satisfactory. It says that the directive says that a review by a superior in the prosecution service complies with this requirement, but I do believe that we can make an argument that in combination with the Charter of Fundamental Rights, there should be a need for a review by the judicial independent authority. And I would think that we have a case in the Belgium where we ask for a referral to the CGEU on this very question. So yeah, that was it. Thank you very much.